Another day, another solution. Let's talk dirt. A Lis Pendens is not a lien. It's just a notice. And that's why it's powerful. Notice scares buyers, lenders, title companies. It increases risk in a real estate deal, and that's why it can be effective. However, if you don't respect this tool, it can turn on you fast, like a weapon used against its owner. Let's discuss. Lis Pendens look simple. They sound easy, and that's the trap. We're going to cover why courts treat this differently than almost anything else, why good cases can still lose protection, and why bad filings, they can create real consequences for you. If you're thinking about using a Lis Pendens or fighting against one, you really need to understand the risk profile first. In later videos, we will get technical. We'll talk about pleadings, notice requirements, expungement fights. This one is foundational. If you missed this part, everything else goes sideways. Hear me carefully here. A Lis Pendens does one thing and one thing only. It gives notice that a lawsuit exists affecting a property. It's a notice to buyers, lenders, title companies, all third parties for that matter. That's the entire mechanism. No lien is created, no ownership is changed, no court order is issued. In theory, a Lis Pendens does not really prevent a sale if a buyer and a seller really want to go through with a deal. Here's a simple example. John claims that his signature was forged on a deed. Bob is now showing up as the owner. Now, before the property gets sold again, John files suit against Bob, not for money, but to regain his property. And along with the lawsuit, he files a Lis Pendens. Now, John's Lis Pendens warns the world that John has a current lawsuit against Bob where he claims to be the rightful owner. It's a warning so the damage doesn't multiply while the case is heard. It doesn't mean John is right or that he will win. At this point, it's just the notice. So let's continue the example. If a buyer purchases the property from Bob with a Lis Pendens attached, they step into Bob's shoes as a defendant in court. Bob is not frozen in place. He can still try to sell the property. Now enters Susie. Susie sees the Lis Pendens. She knows there's a lawsuit over ownership between John and Bob. If Susie buys anyway, she steps into Bob's shoes. No reset button, no fresh start. If Bob loses to John, Susie loses too, and she gets wiped out. The deed doesn't protect her. The lawsuit follows the land. Court orders bind her. Bob's title problems become Susie's. Now here's where most people get tripped up with Lis Pendens. They think that by filing a lawsuit, they automatically qualify for Lis Pendens. They don't. Not even close. In John's case, it works because the case is about ownership to real property. It's about title, who actually owns the property, and whether there was a forgery. Most lawsuits aren't written like that. Many are about money, damages, broken promises, pressure tactics. See, those cases don't qualify for a Lis Pendens. Lis Pendens are allowed only when the property itself is directly in dispute, not leverage, not for punishment, not for strategy. And courts don't take guesses. They read the lawsuit. The live petition controls. If the claim doesn't support a property interest, the Lis Pendens is vulnerable from day one. Texas courts and law take Lis Pendens seriously because they can also be abused and they can easily turn into tools of delay and harassment. That's why many people initially believe they are liens. In fact, many litigants do file Lis Pendens solely for causing delay. Lis Pendens are meant to protect the system and, most importantly, property rights. But if they are used improperly, they cloud title instantly. They affect third parties who aren't in court. They affect buyers, lenders, title companies. So courts demand honesty and discipline, and they will look closely at the actual lawsuit and the filings for motivation and form, and whether the filing matches the claim. The court will also closely look at the Lis Pendens notice itself and whether it was mailed in compliance with Texas law. When it meets all of the criteria, courts will protect its use. When it doesn't, courts shut it down immediately and usually with harsh consequences. Unlike other areas of law, you have to be perfect in your initial filings, or the protection is lost, and in most cases, it can't be cleaned up later. This is where people get burned. The other side doesn't sit quietly. They file a motion to expunge. Now the spotlight is on you. The judge looks at your pleading, your notice, your timing, and your purpose. If the claim doesn't support a property interest, the lis pendens comes off, sometimes immediately. And sometimes the judge asks more. Why was this filed? Was it impermissible? Was it to put undue pressure, sloppiness? Sanctions get discussed. This tool demands restraint. Used properly, it protects real property rights. Used carelessly, and it becomes a big problem for the filer. In the next video, we break down pleading traps and notice requirements. That's where most filings fail. If this video helped you, please like and subscribe below. These videos are for educational purposes only, and they're not meant as legal advice. If you're needing specific help, we'll be glad to help you. You can find our firm's information in the links below. As always, thank you for watching.